Hey guys, so I wanted to talk about a new case that's been filed in the Northern District of California. It's called Anna Runkle, well, probably backwards, Ria Tate, who is the president of the California Board of Psychology. And what this case involves is a relationship coach called Crappy Childhood Fairy, a life coach who had experienced childhood trauma herself and then decided to teach people who would pay her how to basically relieve stress and be able to function in life despite having maybe faced trauma in your life. And so she started this coaching business, and she says that she offers monthly memberships with large group webinars, group Q&A calls, and a private Facebook community, as well as small group coaching programs, live workshops, and retreats where people can learn and apply her teaching to calm overwhelming reactions to stress, improve their own lives through better decision-making and relationships, and other simple techniques to empower her client. She does not treat or heal anyone or perform therapy. I presume that she says those things in her terms of service, and yet the California Board of Psychology disciplined her or tried to tell her to stop practicing what they thought was psychology without a license in California, and California defines the practice of psychology as including but not restricted to assessment, diagnosis, prevention, treatment, and intervention to increase effective functioning of individuals, groups, and organizations. So, to increase effective functioning of individuals, groups, or an organization. That language right there was the key language, I think, that the lawyers who are representing Ms. Runkle claim in the complaint, which was filed on June 3rd, 2026. That language is too broad and vague. Basically, does not help people who do coaching to know when are they practicing psychology versus doing permissible coaching. Is California basically saying you can't be a coach at all because it aligns too closely to the practice of psychology? And so these lawyers have filed this lawsuit against the California Board of Psychology, saying that this California statute that defines the practice of psychology is too vague and too broad to be constitutionally enforceable. And because you wouldn't know. So the principle of vagueness is a legal principle, and overbreadth is another legal principle, both of which kind of hinge on the very broad, ambiguous statutory language that is really hard for a person to know, am I violating the law or not? I'm going to go through a deeper dive for my paid subscribers, but I wanted to alert you to this case in case you know you are a coach or coaches, because I think this case will be really important to watch to see how the court proceeds. But I'm going to talk a little bit more about some other cases and my personal thoughts on this case and for the paid subscribers.